Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Guzman-Garcia, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. May the 4th be with you all. If I made that joke last year, I apologize, but I also intend to make that joke next year. So I really don't apologize. Just finished recording the cases, and they are many, and they are complicated. The force is strong this week. Here we go. First up is Arcos Sanchez v. Attorney General of the U.S., published by the Third Circuit on May 5th, 2021. The Third Circuit had a bit of a moment this week, publishing 3 decisions. We'll start off with the good because why not choose to be happy? This case is about administrative closure. Judge Maddie dissented. Mr. Arcos Sanchez was brought to the United States in 2002 from Mexico without authorization, at the age of 7. He held DACA for many years, but in 2019 he was arrested and charged in New Jersey with sexual assault and endangering the welfare of a child. Even though he didn't have a conviction, USCIS revoked his DACA status due to the charge, detained Mr. Arcos Sanchez, and initiated removal proceedings, where Mr. Arcos Sanchez applied for the only form of relief available to him, asylum and related relief. An immigration judge in what appeared to be detained and therefore quickly done removal proceedings denied everything. 2 weeks later, the state of New Jersey dismissed all criminal charges. Mr. Arcos Sanchez immediately reapplied for DACA. But now his case was on appeal to the BIA, where Mr. Arcos Sanchez challenged the denial of asylum relief and then alternatively requested remand so the IJ could administratively close his removal proceedings while he reapplied for DACA. Now true, non-citizens can obtain DACA even if they have final orders of removal, but no one wants that, including the Obama administration when they implemented DACA. The BIA dismissed the appeal and denied the motion, holding that immigration judges lack authority to administratively close cases because, and despite employing the procedure since the 1980s as a docketing tool to, quote, temporarily pause removal proceedings, end quote, Jeff Sessions said that immigration judges in the BIA lack authority in 2018 in matter of Castro Tum. Attorney General Sessions had room to issue that decision because, as the Third Circuit recognizes here, quote, the regulations governing IJs and the board do not expressly authorize the practice, end quote. And as we all know, the prior administration appeared to work overtime and right up to the very end to fill in any perceived ambiguity in immigration law with its preferred interpretation, which coincidentally almost never favored non-citizens. Anyway, here the Third Circuit held, in agreement with the Seventh and Fourth Circuits but in disagreement with the Sixth Circuit, that immigration judges and the BIA do have authority to administratively close cases. this is because various regulations do, quote, explicitly and implicitly confer broad powers on IJs and the board to manage their dockets, end quote. And like the 7th and 4th Circuit, the 3rd Circuit held that the regulations unambiguously provide this authority. Therefore, the 3rd refused to grant deference under the Supreme Court's Kisor decision to Attorney General Sessions' contrary interpretation of the regulations. Really, the 3rd Circuit's rationale largely tracks the 4th Circuit's in Romero v. Barr. Plus, that 7th Circuit decision that the 3rd Circuit is agreeing with was authored by now Justice Amy Coney Barrett. So that's always a good warm blanket for a court to wrap itself in. Congratulations Jared Gonzalez and Cheryl Lynn for petitioner. Like Billy Idol, I've got more. This case was argued when the prior administration was still in office in January, and so we don't know if now Attorney General Garland is still instructing his oil attorneys to go into court and defend Castro-Tum. But if Attorney General Garland had plans to do something with administrative closure, he could have made moves to have this case taken off the 3rd Circuit's docket after oral argument. Unsure if that happened or not, or what the Attorney General has in store to resolve the Castro-Tum circuit split. Might Castro-Tum go the way of matter of Silva Trevino? If Petitioner's Counsel or the oil attorneys would like to email me and let me know what happened behind the scenes, I'm all ears, and will guarantee you a shout-out on the most prestigious immigration podcast known to man. No offense meant to my good friend John Khosravi. Moving on, the dissent, like Jeff Sessions and the 6th Circuit, lamented the fact that administrative closure sometimes lasts a long time. But as the majority states, such concerns have nothing to do with whether IJs and the BIA have authority to admin close, but rather whether they're wielding it appropriately. And in any event, in a, quote, ripe for admin closure motions in any circuit besides the 6th, the majority states that, as with requests like Mr. Arcos Sanchez's, quote, the Attorney General's Castro-Tum decision fails to acknowledge the fact that allowing time for the IJ or the board to receive the outcome from another tribunal or agency enables resolution of relevant questions and thus facilitates the timely disposition of a removal case, end quote. Turn that AG rationale on its head, practitioners. The dissent also cites to a Yale Law Journal note on administrative closure authored by fellow KKTP attorney Elizabeth Montano. Quite the honor. A few months ago, the dissenting 6th Circuit judge also cited to Liz's note, but for the opposite proposition, that the regs allow for administrative closure. So 2 different dissenting judges citing to the note to support opposite conclusions. I think that means you wrote a good note, Liz. Finally, and for another week, a court is noting that the Department of Justice amended the regulations to preclude administrative closure for all cases initiated after January 15, 2021. But having reviewed Ayla's outrageously helpful page tracking the status of the Trump administration changes, I confirmed that reg is subject to a preliminary injunction in Central Legal de la Raza et al. v. EOIR. Hopefully the Biden administration stops fighting the case or revokes the regulation so that injunction, in some form, becomes permanent. I've provided links to the helpful Ayla page and to that case in the show notes. And that is Arcos Sanchez, the Attorney General of the U.S. Next is Romero v. Attorney General of the U.S., published by the 3rd Circuit on May 5, 2021. This is a Pereira-type jurisdictional case that doesn't even cite to Ms. Chavez, likely because the decision was issued 5 days after Ms. Chavez was issued. We'll see if it gets amended, but it probably will not. In relevant part, Mr. Romero was physically removed from the U.S. pursuant to a final order of removal. After he unlawfully re-entered the U.S., DHS reinstated the final order, but because he expressed a fear of return to Guatemala and passed his reasonable fear interview, DHS served him with a notice of referral to an immigration judge, thereby placing him in withholding-only proceedings as the statute requires. But the notice of referral, known as a Form I-863, did not have the date, time, and location of Mr. Romero's first withholding-only hearing. But a subsequent notice did. Separate from that, we have the Pereira issue. To recap, in Pereira v. Sessions, the Supreme Court held that notices to appear, or NTAs, lacking the date, time, and place of an initial removal hearing as required under INA Section 239A, do not implicate the stop time rule under INA Section 248D, and therefore don't stop a non-citizen from accruing the continuous physical presence required to obtain non-LPR cancellation of removal. But Mr. Romero's case doesn't concern NTAs or cancellation of removal. Nevertheless, Mr. Romero argues that the immigration judge lacked jurisdiction over his withholding-only proceedings based on the allegedly deficient notice of referral to an immigration judge served upon him. The Third Circuit dealt with the NTA issue following Pereira in Accommo v. Attorney General of the U.S., and held that defects in the NTA are not jurisdictional and that termination is not required. So that's pretty bad for Mr. Romero's argument. Not only that, but unlike INA Section 239A with NTA requirements, quote, no statute or regulation defines the contents of a notice of referral, end quote, and the governing regulation, 8 CFR 1208.2 C3II, appears to contemplate that the time and place of a withholding-only proceeding can indeed be provided in a follow-up notice. As Mr. Romero only challenged the IJ's jurisdiction and not the substantive denial of withholding of removal, the Third Circuit denied the petition for review. One more thought. In denying Mr. Romero's motion to terminate below, the BIA noted that it lacked the authority to terminate proceedings because Mr. Romero was in withholding-only proceedings. That's an interesting point that I would have liked the Third Circuit to address a bit. And it kind of makes sense. After all, if the IJ or the BIA indeed terminated the withholding-only proceeding, all that would be left, it would seem, would be the final order of removal that DHS has already reinstated, meaning that theoretically, Mr. Romero would then be subject to removal. Of course, that whole framework screams of a due process and regulatory violation, but it does show that Mr. Romero's position might be counterintuitive in this case. Perhaps the stronger argument with these types of cases is that the final order can't be reinstated in the first place because the initial NTA and those initial proceedings lack the time and place of the first hearing as required of NTAs. I believe a reinstatement challenge such as that would be made with ICE itself and then skip the IJ and BIA and go directly to the circuit. At least in the Ninth Circuit and I believe other courts. And that is Romero v. Attorney General of the U.S. Wrapping up the Third Circuit decisions, we have K.A. v. Attorney General of the U.S., published on May 4th, 2021. Hope you enjoyed that quickie because this is a big one about motions to reopen and theft-based aggravated felonies. And it's not without its twists and turns. Mr. K.A. is from Nigeria and entered the United States without authorization in 1994. He married a woman, a U.S. citizen, but in or about 2002, he was convicted of possession of a controlled substance with intent to distribute, and also with second-degree New Jersey robbery in violation of New Jersey Statute Section 2C:15-1, and he was imprisoned until 2008. DHS detained him and initiated removal proceedings. Not so difficult to do because he entered the U.S. unlawfully, and so he is removable. Mr. K.A. was released from detention and started a relationship with another woman. But he was pulled over for a DUI, and the car contained evidence that he was committing tax fraud. So he went back to prison. Meanwhile, in removal proceedings, he applied for asylum and related relief, premised on, quote, Decree 33, a Nigerian law that authorized prosecutions for drug convictions abroad, end quote. And an IJ actually granted him deferral of removal under the Convention Against Torture. But the BIA reversed on DHS's appeal and remanded the case. And so, an order of removal became final against Mr. K.A. Simultaneously, it appears that Mr. K.A. was in pretrial detention for that tax fraud crime for years, and a criminal court eventually dismissed all charges for lack of speedy trial. During his years in pretrial custody, Mr. K.A. entered a relationship with his cellmate, a man, and Mr. K.A. claims that he now identifies as bisexual. This is important because, quote, in 2014, Nigeria enacted the Same-Sex Marriage Prohibition Act. That law criminalizes same-sex marriage, same-sex cohabitation as sexual partners, as well as other conduct, such as public displays of same-sex affection." End quote. Mr. K.A. was transferred to an immigration detention facility for removal, but it seems like counsel filed a motion to reopen and a stay request for him at the last minute, and he never boarded the plane back to Nigeria. He moved to reopen proceedings so he could apply for asylum and related relief based on his changed personal circumstances of bisexuality of that anti-same-sex cohabitation and affection law in Nigeria. Now, his asylum and withholding of removal claims brought in the motion to reopen should be dead on arrival because in that previous underlying decision from the immigration judge, the IJ held that his possession with intent to distribute was an aggravated felony, and he spent more than 5 years in prison, making it a particularly serious crime. But counsel argued in the motion to reopen that the Supreme Court's Mathis and Moncrief decisions, both published after the IJ and BIA decisions in this case, changed all of that. And counsel might be right. Mathis and Moncrief very well may have changed the calculus. And the BIA didn't even want to touch it on the motion to reopen. Rather, the BIA denied the motion based on a finding that even if the drug crime is no longer an aggravated felony, New Jersey's second-degree robbery is also an aggravated felony, a theft offense, as defined at INA Section 101A43G. So, according to the BIA, Mr. K.A. is still barred from asylum and withholding of removal because, remember, he spent over 5 years in prison, making the conviction a particularly serious crime, even for withholding of removal purposes. And here, the Third Circuit agreed, after applying, as it must, the categorical approach. Under Supreme Court precedent, an aggravated felony theft offense has 3 elements. Quote, 1. The taking of property or an exercise of control over property. 2. Without consent. And 3. With the criminal intent to deprive the owner of rights and benefits of ownership, even if such deprivation is less than total or permanent. End quote. So if a state conviction like this New Jersey statute matches all 3 elements, it's a categorical match to an aggravated theft offense as defined at INA Section 101A43G. This decision is mostly about that second element, the requirement that the theft occur without the victim's consent. And here, the Third Circuit created a circuit split with the 4th, 11th, and 9th Circuits, and even the BIA, holding that the without consent element is met even if the consent in the criminal statute can be obtained by fraud or deceit. So in the Third Circuit, a statute that criminalizes theft through consent obtained by fraud or other trickery, or consent that is otherwise not voluntary or intelligent, will meet the definition of an aggravated felony theft offense. Devastating circuit split. The Third Circuit so held for a few reasons, including historic overview of theft crimes and the landscape at the time of the aggravated felony's implementation. But the Third Circuit also relied on the fact that, quote, a construction of the without consent element to mean without assent would exclude a multitude of state law theft crimes from the federal generic definition, end quote. Really punching us immigration practitioners in the gut there. With that definition in mind, the Third Circuit compared the New Jersey second-degree robbery statute and held that it matched. New Jersey robbery requires commission of an underlying theft, and theft in New Jersey is very broad and was very broad at the time Mr. K.A. was convicted, and it included theft by deception or extortion, both of which would probably not satisfy the theft definition applied in the 4th, 11th, or 9th Circuits or at the BIA. But now due to this decision, it does satisfy the Third Circuit's definition. Among other noteworthy things, New Jersey theft also criminalizes theft of services, which the court also held matches the definition of a theft-based aggravated felony. So Mr. K.A.'s robbery conviction is an ag fel, meaning that even if Nigeria is persecuting bisexual individuals, he's ineligible for asylum and withholding of removal. And because Mr. K.A. did not alternatively argue that he was now eligible for cat deferral, the only remaining form of protection eligible to someone convicted of an aggravated felony and who has spent at least 5 years in prison, the Third Circuit dismissed the appeal of the denial of the motion to reopen. So a big loss for Third Circuit practitioners after what seems like a couple of months of big wins. Allow me to continue. A grenade of a decision that you must distinguish if you're in the Third Circuit, and I encourage you to read the case thoroughly because there's a lot to distinguish. Before this decision, the fact that fraud crimes often don't constitute theft, and theft crimes often don't constitute fraud, was so well settled that Attorney General Barr had to make up new interpretations of the categorical approach in matter of reis, discussed on episode 14 of the podcast, to ensure that crimes like New Jersey robbery nevertheless would match the definition of an aggravated felony. And by the way, no circuit has in any way yet relied upon matter of reis by published decision. The Third Circuit also rejected counsel's very intelligent argument that under New Jersey law, a certain affirmative defense based on a, quote, honest but mistaken claim of right to property, quote, is unavailable for robbery, unlike with other crimes, meaning that actually, robbery convictions in New Jersey might occur based on a mistake, at least when it comes to the theft element. But the Third Circuit summarily rejected the argument, stating, quote, affirmative defenses have no role to play in the categorical approach, end quote. But maybe, just maybe, Third Circuit practitioners, there's a chutzpah argument to be made. Just bear with me here because I'm usually on the other side of this argument. But as I mentioned, according to the Third Circuit, the BIA held otherwise on this without consent issue in its 2008 decision, matter of Garcia-Madruga. As I read this Third Circuit decision, the court isn't saying that the statutory text of the aggravated felony theft offense unambiguously requires its conclusion. In fact, the court states merely that, quote, the statutory text favors, end quote, its reading, and that nothing, quote, in the INA's text or structure undermines this conclusion, end quote. To me, that all leaves room for the argument that the aggravated felony theft statute at INA section 101-843G is ambiguous on the without consent element. And if the definition of theft as used in the aggravated felony provision of the INA is ambiguous, an argument exists that the Third Circuit is actually bound by the BIA's definition pursuant to Brand X in matter of Garcia-Madruga. Now, I'd have to read matter of Garcia-Madruga, and the argument is complicated with persuasive counter-arguments. But the argument might just be there. And that is K.A., the Attorney General of the U.S. Next up, Guzman-Garcia v. Garland, published by the Seventh Circuit on May 3, 2021. This is a short case about asylum. Mr. Guzman-Garcia is from Mexico, and in 1999, he witnessed his brother's murder by gang members in Acapulco. He narrowly escaped himself. Police advised him not to report the crime, and a year later, unidentified men who looked similar to the murderers shot up Mr. Guzman-Garcia's home. And word spread around that unidentified men were looking for him in Acapulco. He moved to another part of Mexico for 5 years, and he lived there unharmed, and he came to the U.S. in 2006. Once apprehended in 2013, he applied for the only form of relief available to him, asylum and related relief. An immigration judge and the BIA denied, and so did the Seventh Circuit. First, on timeliness grounds. Non-citizens must file for asylum within 1 year of entering the U.S. unless they can meet certain narrow exceptions. Mr. Guzman-Garcia did not, and so the Seventh Circuit agreed that he was barred from asylum. Now, apparently the immigration judge alternatively denied asylum as a matter of discretion, a fairly difficult finding for an IJ to make, and Mr. Guzman-Garcia challenged it before the Seventh. But because the 1 year bar is itself dispositive, the Seventh Circuit didn't reach the issue. Remember to challenge all dispositive elements of a case on appeal, practitioners. Turning to withholding of removal, it's not discretionary, and it's not subject to the 1 year bar, and so Mr. Guzman-Garcia challenged it on petition for review. But the Seventh Circuit dismissed the challenge. It held that under its deferential standard of review, quote, the record does not show that Mr. Guzman-Garcia is likely to suffer persecution due to his experience as a witness to an incident of gang violence 20 years ago, much less that there is no substantial evidence to support the IJ's determination to that effect, end quote. His family hasn't been threatened since he entered the U.S., nor was he threatened during his 5 years in Mexico after he left Acapulco. A fairly straightforward gang-based asylum denial. Although I would have liked the Seventh Circuit to have wrestled with, say, Mr. Guzman-Garcia having witnessed his brother's murder and narrowly escaping it himself, and deciding whether it rose to the level of past persecution, such that he was presumed to have a well-founded fear of future persecution and be eligible for withholding of removal. But the IJ and the BIA denied for a lot of reasons, so even if that had been the case, it looks like Mr. Guzman-Garcia would not have succeeded. And that is Guzman-Garcia v. Garland. Next is Gonzalez-Veliz v. Garland, published by the Ninth Circuit on May 4th, 2021. This case is primarily about abandonment of asylum claims. Ms. Gonzalez-Veliz is from Guatemala, entered the U.S. in 2016, was placed in removal proceedings, and pro se indicated that she intended to apply for asylum and related relief. An immigration judge provided her 2 continuances, totaling nearly 4 months, to file an asylum application. And at her 3rd master calendar hearing she did so, with the assistance of an attorney. At the 4th hearing, the IJ told her that she needed to submit proof of having her biometrics taken, i.e. fingerprints, by the time of the merits hearing in 3.5 months. To do so, and double-check me on the instructions, practitioners, Ms. Gonzalez-Veliz would need to mail a copy of her I-589 and other information to USCIS, wait for USCIS to mail her a notice of her biometrics appointment, and then attend that appointment. As removal defense attorneys everywhere know, Ms. Gonzalez-Veliz can't do any of this online, and can't just go out and have her fingerprints taken at a police station and submit them to ICE, as outrageously efficient as any of that sounds. And as everyone listening also knows, USCIS can be quite inefficient, rejects filings erroneously, sometimes just loses things, and often takes months to provide receipts for no discernible reason. Anyway, the IJ said if Ms. Gonzalez-Veliz didn't have her biometrics taken, he'd find her application abandoned. Quite the harsh punishment considering what a meritorious asylum application represents, but to be fair, that's not all on the IJ, it's largely a structural flaw. As I understand it, IJs aren't allowed to hold a merits hearing on relief applications if the biometrics aren't taken. And the former administration made clear that IJs' jobs depended, in part, on their completing cases as quickly as possible, especially asylum cases. A month before the hearing, Ms. Gonzalez-Veliz, through counsel, filed a motion to continue the hearing to obtain what she deemed necessary corroborating evidence. The IJ denied the motion. Then at the merits hearing, Ms. Gonzalez-Veliz, speaking for herself because her attorney was running late, told the IJ that she had not had her biometrics taken, that she didn't speak English, and that she really didn't understand what was going on. Once the attorney arrived, the attorney explained that they had indeed submitted the required documentation to USCIS to get a biometrics appointment, but USCIS hadn't scheduled the appointment or even sent them a receipt showing that it was submitted. Things got pretty testy between the IJ and the attorney, and the IJ was clearly dissatisfied with the attorney's proof that they had properly submitted requests for biometrics. The IJ denied the asylum application as abandoned on DHS's motion, and the BIA affirmed. The Ninth Circuit did too. It noted that the regulations, 8 CFR section 1003.47c, permits an IJ to deem an asylum application abandoned, as does another regulation for failure to comply with biometrics. The court rejected Ms. Gonzalez-Veliz's argument that her duty to comply ended when she submitted the biometrics request to USCIS, because the regulations placed the burden on the non-citizen. In a quote that doesn't quite square with Justice Gorsuch's decision against the government last week in Ms. Chavez, the Ninth Circuit stated that in actuality, quote, the possibility of the government's failure to issue the requisite notices is contemplated by the instructions, which tell the alien to call a particular number if she does not receive the requisite notices after her submission, end quote. And apparently this aligns with decisions out of the 1st, 7th, and 10th Circuits. The Ninth Circuit implied that circumstances might have been different if Ms. Gonzalez-Veliz had requested a continuance to comply with the biometrics requirement, instead of simply to obtain necessary evidence. And the Ninth Circuit distinguished this case from its prior biometrics-type cases that favor non-citizens. The IJ also did not violate Ms. Gonzalez-Veliz's due process rights with any of the actions because sufficient continuances were given and all necessary information was explained. So, Ms. Gonzalez-Veliz cannot apply for asylum, and we don't know whether it was USCIS's fault that the biometrics appointment wasn't ever scheduled. Allow me to ascend the soapbox. Not gonna lie, I got physical anxiety reading this decision. It's really every attorney's worst nightmare. Candidly, based on this decision at least, it appears that the immigration attorney could have filed a better motion for a continuance, and should have followed up on the biometrics notice and submitted better proof with the IJ. But on the other hand, a non-citizen's life is potentially on the line, and most of the issues here are structurally absurd. Why should a non-citizen have to request that USCIS, which is not even a party to removal proceedings, set a biometrics appointment? Many removal defense practitioners are overworked, and USCIS doesn't permit direct contact of field offices. And if you can even get a human being on the line when you call their main number, an Olympian feat in and of itself, that human being is a contractor who knows next to nothing about a case and is almost always unhelpful. Are we really content as a country with a system that requires attorneys to mail requests for fingerprint appointments without any immediate proof of submission, and then hound USCIS for an appointment? Why can't appointments be scheduled online like even the DMV allows? Or why not simply have ICE send out automatic biometrics appointments once an application is filed in court and served upon ICE? The system is not set up to help asylum seekers, and so everyone, IJs, Respondents' Council, Respondent, ICE, and the BIA, at times become the villain in these decisions. But to me, it's the system that seems most blameworthy, making decisions like this inevitable, where no one really wins. Okay, soapbox rant complete. And that is Gonzalez-Veliz v. Garland. Heading to the Eighth Circuit for a second, we have Artola v. Garland, published on May 5th, 2021. This case is about cancellation of removal and whether temporary protected status is an admission in the Eighth Circuit. Heads up, it appears it's not. Mr. Artola is from El Salvador, entered the United States unlawfully, and obtained TPS in 2003. In May 2008, he became a lawful permanent resident. Unsure how he pulled that off considering his entry without inspection, the decision doesn't say, but so be it. Congratulations, sir. But in April 2012, he was found with cocaine, and later convicted of drug possession. He traveled abroad in 2018, and upon his re-entry, DHS learned of his conviction and placed him in removal proceedings. He applied for LPR cancellation of removal under INA Section 240AA, which both the IJ and the BIA denied. And the Eighth Circuit did too. To be eligible for LPR cancellation of removal, rather than non-LPR cancellation of removal, often discussed on the podcast and at issue in Ms. Chavez, a non-citizen must show that he's been an LPR for at least 5 years, and that he has resided in the United States continuously for 7 years after having been admitted in any status. Mr. Artola has the 5 years in LPR status, so this case comes down to that second requirement, the 7 years in any status. Everyone agrees that under the statute, his continuous residence stopped in 2012, when Mr. Artola committed the drug crime. That's due to the other non-NTA portion of the stop time rule not discussed in Ms. Chavez last week. And in 2012, Mr. Artola had only been an LPR for about 4.5 years. So unless TPS qualifies as, quote, admitted in any status, end quote, under the LPR cancellation statute, Mr. Artola is ineligible for LPR cancellation. The Eighth Circuit held that yes, indeed, this is the case. It recognized that in Velazquez v. Barr et al., published just a few months ago and discussed on episode 27 of the podcast, the Eighth Circuit held that a grant of TPS was an admission, at least such that an individual is eligible to adjust to LPR status, provided that they meet the other requirements. But that holding, according to this Eighth Circuit panel, was because the language Congress used in the TPS statute, quote, creates a legal fiction for adjustment purposes, end quote. It's not, as I admittedly kind of thought when reviewing Velazquez, that TPS is itself an admission. This Eighth Circuit panel held instead simply that TPS treats recipients as, quote, maintaining lawful status as a non-immigrant, end quote, and non-immigrants are necessarily, quote, inspected and admitted, end quote, meaning that TPS recipients are eligible to adjust to LPR status provided that they have a visa immediately available to them, say by marrying a U.S. citizen. But if you're a bit confused why that all doesn't mean that TPS recipients have therefore been admitted as required under the LPR cancellation of removal statute, so am I. But as TPS is not an admission according to the panel, so the logic goes, a TPS recipient has not been, quote, admitted in any status, end quote, as required of the LPR cancellation of removal statute. The whole issue will probably be resolved one way or the other by the Supreme Court in a few months. Now true, the TPS statute itself provides that if a TPS applicant can establish extreme hardship, time in TPS can actually satisfy the continuous presence required of LPR cancellation of removal. But according to the Eighth Circuit, for that to even potentially come into play, a TPS recipient must have been admitted first. That is, I guess, entered on some sort of non-immigrant visa, had that non-immigrant visa expire, and then received TPS afterwards. Unsure. The Eighth Circuit didn't really explain what type of situation would allow for a TPS recipient to satisfy the continuous residence required of LPR cancellation, stating that the statutory text says what it says, even if the interpretation gives the statute no practical effect. Indeed, even the Eighth Circuit seems vexed, calling the TPS statute at issue, quote, facially nonsensical, end quote. Might use that term against opposing counsel at my next argument. See how it goes. Mr. Artola, therefore, is ineligible for LPR cancellation of removal. Interesting case. Two simpler things after discussion of admissions, which always seems to take extra mental strength on my part, and which I'll be returning to on the next case. Note: it does not appear that DHS treated Mr. Artola as an applicant for admission under INA Section 101A13C upon his return, as it likely had authority to do, which may have complicated or even precluded his cancellation claim in the first place. Just another reminder that LPRs with criminal history need to be very, very careful about traveling. Finally, nerdy pet peeve of mine, the Eighth Circuit recognizes and quickly disregards OIL's request to give the BIA's unpublished decision in this case Skidmore deference, an ancient form of agency deference that predates Chevron by like 40 years. Has any court granted Skidmore deference recently? Has the argument ever won the day in immigration proceedings? Skidmore seems to be the perennial footnote that all parties need to recognize and argue with little practical effect. Of course, no offense meant to Jim Skidmore, the Swift & Company, or their dispute from 1944. And that is Artola v. Garland. Heading back to the Ninth Circuit and rounding out the episode, we have Rout v. Garland, published on May 6, 2021. This decision is about dates of admission and CIMTs. And it's a heady one with a very smart law professor in Mr. Rout's corner. I told you at the start of the episode it's a complicated week. Mr. Rout is from the Federated States of Micronesia. Staying on the subject of immigration law is crazy, and I learn something new every week. It turns out that under a 2003 law, citizens of Micronesia can enter the U.S. and work on special non-immigrant visas only for Micronesians. Unlike pretty much all other non-citizens, quote, Micronesian citizens can enter, reside in, and work in the United States without visa approval or labor certification, end quote. Mr. Rout did this in 2005, went back to Micronesia for about 2 weeks in 2015, and then re-entered the U.S. in 2015 in that same unique non-immigrant status. So he was essentially in the U.S. for 10 years, continuously and lawfully in this special Micronesian non-immigrant status, save for a 2-week return to Micronesia. But while in Hawaii in June 2018, Mr. Rout was convicted of unlawful imprisonment in the first degree, a Class C felony, in violation of Hawaii Revised Statute Section 707-721-1. Mr. Rout was sentenced to 68 days imprisonment and 4 years probation. He was placed in removal proceedings, where an immigration judge determined that the Hawaii conviction was a CIMT, for which a sentence of 1 year or more could be imposed. And that because Mr. Rout was convicted of it within 5 years of his 2015 admission, he was removable under INA Section 237A2AI. The BIA affirmed, relying on its 2011 decision in matter of Aliagi, wherein the BIA held that for purposes of this ground of removal when someone has adjusted to lawful permanent resident status in the U.S., note, not the case with Mr. Rout, the 5-year period does not reset when the non-citizen adjusts to lawful permanent resident status. Rather, and at least for someone like Mr. Aliagi, who entered as a non-immigrant and then adjusted to LPR status in the U.S. without leaving the U.S., the relevant period for the 5-year clock under INA Section 237A2AI is that first entry as a non-immigrant, not the adjustment of status in the U.S. So a fairly favorable rule for non-citizens, at least those who adjust to LPR status in the U.S. and then commit a CIMT. Alright, so that's matter of Aliagi. Now, the Ninth Circuit subsequently held in Fugao v. Barr that the same Hawaii statute at issue here is a CIMT. So the issue before the Ninth Circuit is this. Is matter of Aliagi sufficiently analogous to Mr. Rout's situation? And if so, is the Ninth Circuit going to agree with matter of Aliagi? Or rather, is the relevant admission the 2005 admission, thereby saving Mr. Rout from removal? The Ninth Circuit deferred to matter of Aliagi. First off, in Aliagi, although the BIA was ultimately concerned with the effects of adjustment of status admissions, the BIA did state that for INA Section 237A2AI purposes, quote, the date of admission refers to the date of the admission by virtue of which the alien was present in the United States when he committed his crime, end quote. So that's 2015 for Mr. Rout, and he committed his crime 3 years later in 2018. Plus, the BIA discussed a hypothetical pretty analogous to the current case, indicating again that 2015 is the relevant admission for Mr. Rout. The Ninth Circuit deferred to matter of Aliagi here under the Supreme Court's Chevron decision, first by, as it must, agreeing with the BIA that INA Section 237A2AI is ambiguous on this issue, that is, the issue of which date of multiple dates, quote, constitutes the date when an individual has multiple admissions preceding a conviction for a CIMT, end quote. And apparently this decision that the statute is ambiguous on this issue aligns with the Fourth Circuit decision as well. Now, although matter of Aliagi wasn't directly under review here, remember that decision was Mr. Aliagi in 2011 and not Mr. Rout, the BIA relied upon it in Mr. Rout's case, and courts, quote, apply Chevron deference regardless of whether the order under review is the precedential decision itself or a subsequent unpublished order that relies upon it, end quote. So long as the unpublished decision, as is the case here with Mr. Rout, quote, is directly controlled by a published decision interpreting the same statute, end quote. Put another way, the Ninth Circuit will review and potentially defer to a published BIA decision relied upon by the BIA in a non-published decision, directly under review, when the issue resolved in the published decision is germane to the unpublished decision under review. Got it? Good. Applying that principle here, the Ninth Circuit held that matter of Aliagi interpreted the phrase, quote, the date of admission, end quote, as used in the statute of removal, even for situations that do not involve an individual's adjustment of status, like Mr. Rout. So then, reviewing the BIA's interpretation under Chevron Step 2, the Ninth Circuit held that the BIA's interpretation in matter of aliagi was reasonable. This is a fairly low standard, which is why some federal judges hate it and certain Supreme Court justices want to vacate Chevron. Reviewing the statutory structure and possible problems of alternative interpretations, the court held the BIA's decision in matter of aliagi reasonable. Mr. Rout had argued that a 2-week trip abroad during 10 years of pretty continuous residence in the U.S. shouldn't restart the aliagi clock, but the Ninth Circuit rejected that, holding that while that is indeed generally the law for individuals with lawful permanent residence status, aka green cards, that's not the case with non-immigrants like Mr. Rout. And again, the fact that Mr. Rout could remain here lawfully as a non-immigrant for 10 years is itself pretty exceptional, stemming, in this case, from that unique Micronesia framework. Turning to that framework, the Ninth Circuit held that it didn't change its decision. Micronesian citizens, like all non-citizens, are subject to the removability grounds at INA Section 237A, and while they get special treatment under the INA, they don't get to avoid matter of aliagi. The Ninth Circuit indeed recognized how harsh this was for Mr. Rout, who has 3 U.S. citizen kids, and who, because he could enter and exit as he pleased, never applied to become a lawful permanent resident, which therefore would have likely prevented his removal. But, quote, "As members of the judicial branch, we cannot impose a different interpretation by fiat when the Supreme Court instructs us to defer to an agency's reasonable interpretation of ambiguous statutory language," end quote. Mr. Rout, therefore, is removable. That was a lot. I say we end the episode. And that is Rout v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.